Another thing obvious that's going on here is how a lot of different small businesses are operating, how people are operating within those small businesses, working remotely, and that the courts are not impervious to that. They're also affected. So, one of the questions that we keep getting is like, what's going on with the courts? And that's kind of changing often. It's not like today is one answer and then that's just going to be the answer moving forward. So as it relates to kind of where we are today, I'll just go through each of you guys, and if you can highlight kind of what has changed and what's the current status as it is today here on April 1st. So Rob, I'll start with you in the Milwaukee area, because there's some things that are kind of new that are, from our firm's perspective, actually really exciting. So can you talk a little bit about kind of what's going on in the Milwaukee and Waukesha court systems, and kind of what else has happened as it relates to all the areas that we service out of the Milwaukee area?
Sure. So I do the Kenosha-Racine counties primarily, and they are also just kind of scrambling to see what is the best course of action. They put certain cases in priority, specifically those that deal with juvenile cases. Any kind of emergency orders they are trying to hear rather quickly, but they're doing everything either telephonically or through Zoom. So I know that I've been in touch with many of the clerk of courts in Kenosha and Racine, and they are trying to set up Zoom hearings, even for evidentiaries or like little mini trials where we can actually have testimony and submit evidence. So they're still working out the kinks with that, but I'm hopeful that we'll have more information with that soon. I know that in Waukesha, they're taking a similar approach. They are wanting to conduct hearings telephonically and by Zoom. And I also believe that Milwaukee is putting together a process to allow for divorces to proceed without actually having to appear, but by simply just signing an affidavit, which is just a sworn statement by parties. And I believe that it has to be signed by both parties and their attorneys, which that last part does create somewhat of a concern in how we help people who may not have an attorney, or if one person does have an attorney. So I know here at Sterling, we're working diligently to help parties who may not be represented, to allow for them to be able to facilitate their divorce through this new means of simply signing an affidavit.
Awesome. And I do believe the Waukesha County Court is applying the same type of thing. That was
correct.
Information I got from Holly. Awesome. So Katie, down in Illinois, kind of what changes have you seen take place since the beginning of March, and kind of how has that roller coaster evolved?
I think a roller coaster is the exact way to describe it currently. So it feels like every day something new comes out, and it's a constantly evolving, constantly changing, world we're living in right now. So yeah. I can comment on everything that I know as of today. Yeah. So Cook County extended their courtroom closures through May 18th of 2020. I believe that DuPage is still closed through effective like April 17th. I think Kane and Kendall have also closed through either April 17th, or I think Kane now is through April 20th. If you were to ask me, in terms of courtroom procedures, what is still occurring or what is still able to occur, it honestly is county specific at this point. I can say that most of the courthouses are still open for essential proceedings. So orders of protection, emergency orders of protection, or things related to safety concerns can still be addressed. Also with Cook County in particular, as well as DuPage, they're actually allowing people to submit documents electronically and participate in some domestic relations procedures electronically during this time frame. So it's not like all cases have to halt during this time frame. However, I do know that with anything outside of an emergency related issue, you do have to have a joint stipulation from both sides that they are in agreement to having the case proceed electronically. So if you have one party that doesn't want to agree to this, technically they don't have to. But if both parties are on board with proceeding with respect to the case, then they would sign off on a joint stipulation to do so, and we can still electronically move the case forward by way of a pretrial conference, by way of an uncontested prove up. So these types of things can still happen. Also, they are doing in DuPage now, you can submit pleadings and exhibits as long as, like I said earlier, it's stipulated by both sides. So you can actually have a contested hearing at this point, and the judge would then review everything electronically. There wouldn't be any type of oral testimony taken. You'd be relying on verified pleadings as well as stipulated to exhibits, and then the court could issue some type of a ruling as a result of that. I know
so for us non-legal people, what that sounds like to me is on uncontested cases where you come to an agreement, you can still move those through the court system. You can still get those finalized without actually appearing in court. And they're just using a different mechanism to accomplish that.
That's exactly right. As long as both parties are in agreement that should proceed before the court, you still can submit all the paperwork and it can be entered at this time. Yes.
And Rob, just kind of come back and ask that same question as it relates to what's going on in the Milwaukee area. Even though the courts are closed for in-person things, we're still able to actually function and help people start the process. And Waukesha, if they're both parties represented, we're able to actually finalize that process if we can come to an agreement, and they can both sign that if they're both represented by attorneys. So can you talk about a little bit kind of where we're still able to function in full capacity?
Absolutely. I've been able to initiate motions, get stipulations and orders or agreements between the parties signed and signed by a court, even after this crisis has occurred. So though there is a bit of a delay with respects to getting into a courtroom, we're still able to file motions, enter agreements, and get things signed by court officials to help effectuate the process. So yes, we're still able to move, maybe at a slower pace than we were a month and a half ago, but we're still able to get things resolved.
Awesome. So Janelle, what of this is similar and what of this is different up in the Valley area? And that what that means to us is covering, from down to Fond du Lac all the way up to, Green Bay and, Shawano County and all that area up there. It's quite a wide spread of area, but you talk a little bit about what's going on up by you?
Yeah, we're lucky in the Fox Valley because even though we cover a lot of different counties, we're in almost a dozen different counties up here. Geographically, it's a very condensed area, so it's very easy for us to move throughout the region and make sure that we're in all of those counties. So I'm not going to go through each of them because that would take us an hour. But the general landscape is very similar to what Rob and Katie have dictated with some minor tweaks. First and foremost, throughout the month of March, we've been monitoring this and courts have been receptive and sympathetic to it. So even prior to any directives from our Supreme Court, we were still able to modify and coordinate pretty well. But as of March 23rd, the Supreme Court of Wisconsin actually issued a directive that mandated that we suspend circuit court proceedings that are not emergency in nature. And unfortunately, in the family law context, not many hearings are considered emergency hearings. And so though we're not able to physically get into a courtroom, we still are able to get a lot accomplished because we can still use electronic means. For instance, an attorney in our office, Attorney Jeffrey Morrell, actually coordinated a Zoom conference for the court commissioner in Fond du Lac in order to have an in-person appearance for a temporary order recently. So, Sterling specifically is on the cusp of all of the electronic means, and we make sure that we do everything that we can to coordinate that and keep our cases moving. We know that our clients are in limbo, and delaying these things unnecessarily is not something that we want.
Right.
So to the extent that it's possible, we're still accommodating those things, and the courts are going above and beyond, learning new things along the way to join us in that technology and to join in keeping things moving. They don't want these things lingering on their calendar either. But the Supreme Court of Wisconsin did mandate that through May 21st, we cannot have non-emergency court appearances. Everything that can be held electronically will be held electronically. But I am advising my clients that you do have the right, as Katie indicated, to an in-person court appearance. And so if both parties aren't agreeing to it, we may have to delay some of these things, which can be frustrating for our clients. However, I do want to be very candid in that sometimes I personally, as your attorney, feel it's very important that we be in person to make certain arguments. Certain motions, certain issues very much require my in-person appearance and the judge's in-person attention. As you can expect, telephonic communication, people have distractions, they're not engaged, they're not seeing your reaction, they're not seeing the reaction of the person testifying. There's a lot of things that you can read in a room personally that you just can't do electronically. And so when it is necessary, I'm advising my clients, you know what, we should just wait on this issue. But the vast majority of family law practice occurs outside of the courtroom. So thankfully, we are still able to keep our cases moving. We can still do settlement conferences. Even those can be done electronically. We can still draft, prepare, negotiate, file, and get finalized marital settlement agreements. And as I already indicated, the family court commissioners are able to handle those stipulated final divorce hearings very swiftly. As you can imagine, their calendars have cleared up pretty significantly. And so the calendaring of those things, once we do get them accomplished, is actually a significant speed up rather than a slowdown. So if your case is on the cusp of resolving, you're not going to see or feel that impact. And even those people that are considering filing now, remember in the state of Wisconsin, we have a 120-day wait period for finalizing divorces anyway. We're not anywhere within that time frame in terms of not being able to have a court appearance. So even though maybe we have to do your temporary order telephonically or reach a stipulation in that regard to get that filed, you're ultimately not going to be adversely affected in terms of your timeline here.